If a 50B action or a domestic violence protective order has been filed against you, that domestic violence protective order, or DVPO, which is just sort of a domestic violence restraining order, basically, you have the option of going to court. You do not have to be there. Just like with any lawsuit or civil action, the defendant does not have to appear. Now, if you don't appear, then the plaintiff or the person who filed for the restraining order is basically going to get whatever they want in most cases. That can include vehicles, assets, an order that requires you to give up all the weapons that you may own, temporary custody of children, an order for you to stay away from home, workplace, school, that kind of thing. And so you don't have to be there, but it's always a good idea that you hire an attorney to protect you and then show up to the hearing to avoid any overreaching or unlawful order from being entered against you. Even if you go, that doesn't mean you have to testify. And that doesn't mean there's going to be a hearing. A lot of times DVPO cases are worked out by some agreement, which can even include an order that does not include any findings. So, you know, if you have no interest in seeing that person ever again, then it's fairly easy to have an order entered keeping you away from that person without any court finding or any admission by you that you've done anything wrong or committed any acts of domestic violence. Domestic violence orders also have further reaching consequences that a lot of people don't understand. If you ever want to own firearms legally, if you want to apply for a carry concealed weapon permit in the future, if you have domestic violence protective orders entered against you, that could really jeopardize your ability to do that. So it's always a good idea to have an attorney present with you if you've ever been accused of any type of domestic violence.